I knew something was wrong the morning I found tire tracks cutting fresh ruts through my gravel driveway at 5 in the morning. The sound of engines grinding uphill had woken me from a dead sleep, and by the time I threw on pants and stumbled outside, a line of SUVs was already disappearing around the bend. My name is Yannick Caldwell, and I own a 20-acre property in rural Cascade County, Montana, about 15 miles outside of Great Falls. The property came with a half-mile private road that connected my land to the main county highway. That road was mine, every inch of it, and somehow 300 people from the Meadowbrook Heights HOA had decided it belonged to them too. The whole mess started 6 months earlier when developers broke ground on Meadowbrook Heights, a sprawling planned community that promised luxury mountain living to retirees and young families fleeing California's housing prices. The development sat on the opposite side of a ridge from my property, and according to the original plans filed with the county, they were supposed to build their own access road connecting to Highway 87. But somewhere between blueprints and bulldozers, things changed. The developer, a slick company called Summit Vista Properties, apparently decided that building a 3-mile road through rocky terrain was too expensive. Instead, they found an old easement document from 1952 that mentioned a shared access corridor running through what was now my land. I inherited this property from my grandfather, who bought it in 1978. The deed was clear. The land and everything on it belonged to me. There was no easement, no right-of-way, nothing that suggested anyone else could use my private road. But Summit Vista claimed otherwise, and by the time I caught wind of what was happening, they had already sold 200 homes with promises of convenient highway access via established roadways. The first time I met Brenda Hutchins, the newly elected president of the Meadowbrook Heights HOA, she was standing at the gate I'd installed across my road, talking on her phone like she owned the place. She was exactly what you'd picture, mid-50s, highlighted blonde hair and a severe bob, designer sunglasses that probably cost more than my truck payment, and the kind of rigid posture that screamed, "I'd like to speak to your manager." "Excuse me," I called out as I approached. "This is private property." She held up one finger in the universal gesture for, "Wait," and continued her conversation. "Yes, that's what I'm telling you. The access has been completely blocked. We have 300 residents who need to use this road, and some hillbilly has put up a gate." "This hillbilly owns this land," I said loudly enough that she couldn't ignore me. Brenda turned, gave me a withering look, and spoke into her phone. "I'll call you back." She dropped the phone into her designer purse and crossed her arms. "Are you Yannick Caldwell?" "I am, and you're trespassing." "Actually, we have an easement. Summit Vista provided documentation to all homeowners that this road is part of our community infrastructure." I pulled out my phone and brought up the photos I'd taken of my deed. "This is my property deed, filed with Cascade County in 1978. There's no easement listed anywhere. Whatever Summit Vista told you is a lie." Her expression didn't change. "Well, that's between you and the developer. What I know is that 300 families purchased homes with the understanding that this road provides access to the highway. It's the only reasonable route. The alternative would require driving 15 miles in the opposite direction through unpaved Forest Service roads." "Not my problem," I said. "This is my road. I maintain it. I pay taxes on it, and I don't appreciate strangers tearing it up at all hours." "Tearing it up?" She laughed, sharp and humorless. "Your road is barely maintained at all. It's full of potholes, there's no lighting, and the gravel is insufficient for proper drainage. If anything, our use of it should motivate you to bring it up to community standards." I felt my jaw clench. "Community standards?" "Lady, this isn't a community road. It's my private driveway. I maintain it enough for my own use. If you want a better road, build your own." "That's unreasonable, and you know it. The cost would be astronomical." "Again, not my problem. You bought a house in a development without doing due diligence. That's on you." Brenda's eyes narrowed. "We'll see what our lawyers have to say about that. In the meantime, I'm instructing all residents to continue using this access road as planned. If you interfere with their right-of-way, we'll have you arrested for harassment." She turned on her heel and walked back toward the development before I could respond. Through the gate, I could see a cluster of massive homes perched on the hillside, each one probably worth $500,000 or more. The whole development looked like it had been airlifted from a Colorado ski resort and dropped into the Montana wilderness without any consideration for the existing landscape or property owners. That evening, I called my attorney, Harold Jennings, a semi-retired lawyer in Great Falls who'd handled my grandfather's estate. After I explained the situation, there was a long silence on the other end of the line. "Do you have the original deed?" Harold asked. "Yes, and I've checked it a dozen times. There's no easement." "What about earlier deeds? Sometimes easements get established before a property changes hands." I went back through everything my grandfather left me. Nothing. The only thing I found was some old survey map from 1952 that shows a logging road, but that road was abandoned decades ago and doesn't even follow the same path as my current driveway. Harold sighed. "Okay, here's what we're dealing with. If Summit Vista sold those homes promising road access, they could be in serious legal trouble for misrepresentation. But they're probably banking on the homeowners going after you instead of them, because you're the immediate obstacle. The HOA might try to claim a prescriptive easement." "What's that?" "Basically, if they can prove they've been using the road openly and continuously for a certain period, they might be able to claim a legal right to keep using it. In Montana, that's usually 5 years. But they've only been there 6 months, so that's not applicable yet." "So what do I do?" "Document everything. Take photos, keep records of every interaction, and for God's sake, don't let them establish any pattern of regular use. The longer they use that road, the stronger their eventual claim becomes. You need to shut this down now." I took Harold's advice seriously. The next morning, I reinforced the gate with a heavy-duty chain and posted clear signage. Private property, no trespassing road, not for public use. I also installed a trail camera to document any violations. For 3 days, the gate held. Then, on the 4th day, I came home from my job at the lumberyard to find the chain cut and lying in the gravel. Fresh tire tracks led right through. The trail camera showed exactly what had happened. At 2 in the afternoon, a white pickup truck with Meadowbrook Heights security emblazoned on the door had pulled up to the gate. 2 men got out, cut the chain with bolt cutters, and drove through, leaving the gate wide open behind them. I called the Cascade County Sheriff's Office. Deputy Martinez arrived 40 minutes later, looked at the camera footage, and shook his head. "That's pretty clear-cut destruction of property," he said. "You want to press charges?" "Absolutely." "Okay, I'll need to talk to the HOA security company. You know which one they hired?" "No idea, but I can find out." Deputy Martinez took his report and told me he'd follow up within a few days. In the meantime, I replaced the chain with something even more substantial and added a second trail camera hidden in the trees. The HOA's response came not from the sheriff's department, but from a process server who showed up at my door 3 days later. Meadowbrook Heights. HOA was suing me for interference with established right-of-way and demanding immediate access to the road plus $50,000 in damages for emotional distress and inconvenience to residents. I drove straight to Harold's office with the lawsuit. He read through it carefully, occasionally making notes on a yellow legal pad. "This is aggressive but not unexpected," he said finally. "They're trying to pressure you into settling. They figure you don't have the resources to fight a prolonged legal battle. They're wrong about that. My grandfather left me enough that I'm not hurting for money." "Good, because this could get expensive. Here's what we'll do. We file a countersuit for trespass and destruction of property, and we request an immediate injunction prohibiting their use of the road pending the outcome of the case. We'll also send a letter to Summit Vista putting them on notice that they may be liable for fraud in the sale of those properties." The legal machinery ground into motion slowly. Over the next 2 months, I watched my road deteriorate rapidly. Despite the gate and chains, someone was cutting through almost daily. The trail cameras caught different vehicles each time: residents in sedans, delivery trucks, contractors, even the garbage collection service. My road, which I'd kept in decent shape with occasional gravel loads and a rented grader once a year, started developing serious ruts and potholes from the constant heavy traffic. I documented everything meticulously: every cut chain, every trespasser, every new pothole. Harold filed the injunction request, and we got a court date set for early December, still 3 months away. The breaking point came on a rainy October morning. I was heading out to work when I encountered a moving van completely stuck in the mud where my road crossed a low-lying area that tended to flood. The driver was gunning the engine, making the situation worse as the massive truck sank deeper into the saturated ground. I pulled up alongside and rolled down my window. "You're tearing up my road." The driver, a tired-looking man in his 50s, just shrugged. "I got a delivery to make, man. They gave me this address. This is the only way to get there." "This is private property. You're trespassing." "Take it up with United Van Lines. I'm just doing my job." The truck eventually needed a tow, which required a heavy-duty wrecker to access my road, causing even more damage. By the time they finally extracted the moving van, there was a trench 2 feet deep and 15 feet long carved right through the middle of my road. The repair estimate came back at $4,500. I sent the bill to the Meadowbrook Heights HOA with a certified letter demanding payment within 30 days. Brenda Hutchins responded personally via email this time. "Dear Mr. Caldwell, your road was already in deplorable condition due to your neglect. Any damage is the result of your failure to maintain community infrastructure to acceptable standards. The HOA will not be paying for repairs that are your responsibility as the property owner. Furthermore, we are documenting the hazardous condition of this road and plan to file a complaint with the county regarding the public safety risk you are creating. Sincerely, Brenda Hutchins, President, Meadowbrook Heights HOA." I read the email 3 times, my blood pressure rising with each word. She was actually trying to turn this around and blame me for the damage her community was causing. The community infrastructure phrase particularly galled me. She had fully convinced herself that my private road was somehow public property. Harold's response when I showed him the email was grim. "They're escalating. The county complaint is a smart move on their part. If they can get the county to declare your road a public safety hazard, they might be able to force you to either improve it or open it to public use." Can they actually do that? Maybe. County regulations can be tricky. We need to get ahead of this. He drafted a formal response to Cascade County outlining the ownership situation and the ongoing legal dispute. We also filed an updated complaint adding the moving van incident and the new damage to our tally of violations. November brought snow to Montana, and with it, a whole new nightmare. My road, designed for light use and maintained with minimal grading, became treacherous under winter conditions. I had a small plow attachment for my truck and kept my section clear enough to get in and out safely. But 300 households generating constant traffic turned the road into a mess of packed snow, ice, and hidden potholes. The first accident happened on November 15th. A Meadowbrook Heights resident lost control on a patch of ice and slid off the road into a drainage ditch. Nobody was hurt, but the car was totaled. The woman, a 20-something named Jessica Pitt, actually had the nerve to show up at my door the next day talking about suing me for inadequate road maintenance. "You're responsible for keeping this road safe," she insisted, standing on my porch in expensive winter gear that had probably never seen actual Montana weather before last month. "I'm not responsible for anything," I said. "You're trespassing on my property. If you got hurt doing it, that's your own fault." "The HOA said this was a shared access road. The HOA lied to you. This is my private property, and you have no right to be here." She started crying, which I suspected was a calculated move. "I just totaled my car. My insurance won't cover it because they're saying I was trespassing. I'm a single mom. I can't afford this." I felt a twinge of sympathy but pushed it down. "Then you should sue Summit Vista for selling you a house under false pretenses, or sue the HOA for giving you bad information. But I'm not the person you want to go after. I'm the victim here, not you." She left in tears, and I felt like garbage for the rest of the day. But I also knew that showing any weakness would be a mistake. Harold had warned me repeatedly. Any accommodation, any permission granted could be used to establish that I'd acknowledged their right to use the road. The court date for the injunction hearing finally arrived on December 8th. I drove to the Cascade County Courthouse in Great Falls wearing the only suit I owned, a dark blue number I'd bought for my grandfather's funeral. Harold met me outside, briefcase in hand. "Ready?" he asked. "As I'll ever be." The hearing room was smaller than I expected, just a simple courtroom with space for maybe 30 people. Brenda Hutchins was there with the HOA's attorney, a sharp-looking woman in her 40s named Patricia Kendall. Behind them sat a handful of Meadowbrook Heights residents, presumably there for moral support. Judge Raymond Warren took the bench promptly at 9. He was an older man with silver hair and reading glasses perched on his nose. He reviewed the filings briefly, then looked up. "This appears to be a dispute over a private road and an alleged easement," he said. "Ms. Kendall, your clients are claiming a right-of-way. What's the basis for that claim?" Patricia Kendall stood smoothly. "Your Honor, the basis is a historical easement dating back to 1952, when the property was part of a larger parcel used for logging operations. The easement was established to provide access from the logging areas to the main highway. That easement has never been formally terminated, and therefore remains valid. Do you have documentation of this easement? We have a survey map from 1952 showing the access road, Your Honor. We're still working to locate the original easement agreement, but the continued existence of the road itself demonstrates the established nature of the right-of-way." Judge Warren turned to Harold. "Mr. Jennings, your response?" Harold stood. "Your Honor, the 1952 survey shows a logging road that was abandoned decades ago and no longer exists. The current road on my client's property was built by his grandfather in the 1980s and follows a completely different route. More importantly, there is no recorded easement on the property deed, which has been in my client's family since 1978. The burden of proof for an easement rests with the party claiming it exists, and the HOA has provided no valid evidence whatsoever." "What about prescriptive use?" Judge Warren asked. "The development is only 6 months old, Your Honor. Prescriptive easement requires 5 years of continuous use in Montana. That standard has not been met." The judge made some notes. "Ms. Kendall, has the HOA offered to compensate Mr. Caldwell for use of his road?" Patricia hesitated slightly. "We believe no compensation is necessary given the existing easement, Your Honor. However, the HOA has discussed the possibility of contributing to road maintenance costs." "Discussed but not offered?" "That's correct, Your Honor. We're waiting for resolution of the legal question before moving forward with any financial arrangements." Judge Warren looked annoyed. "So you're using this man's private property, causing significant damage based on the photographic evidence I've reviewed, and you haven't offered him a single dollar in compensation?" "We dispute that it's purely private property, Your Honor. Your dispute is based on a 60-year-old map and no actual documentation." The judge shuffled papers. "Here's what I'm going to do. I'm granting a preliminary injunction prohibiting the Meadowbrook Heights HOA and all its residents from using the disputed road pending a full trial on the merits. Mr. Caldwell is authorized to enforce this injunction through appropriate means, including barriers and signage. The HOA will need to make alternative arrangements for access to their properties. Trial date will be set for," he consulted a calendar, "March 15th. That gives both sides time to gather evidence and hopefully consider settlement." Brenda Hutchins actually gasped audibly. Patricia Kendall maintained her composure, but I could see the frustration in her eyes. "Your Honor," Patricia said quickly, "an injunction would create severe hardship for 300 families. We're talking about people who wouldn't be able to access their homes." "Then they should have ensured they had legal access before purchasing those homes," Judge Warren said flatly. "This is exactly the kind of situation that title insurance and proper due diligence are meant to prevent. I'm sympathetic to the residents' predicament, but that doesn't give them the right to trespass on private property. Injunction granted. Next case." Walking out of the courthouse felt surreal. Harold was pleased but cautious. "This is a good result, but don't celebrate yet," he warned. "They'll probably appeal, and in the meantime you need to be prepared for them to get desperate." He was right. The desperation started that very evening. I returned home to find my gate not just cut, but completely destroyed. Someone had used a vehicle to ram through it, tearing the posts right out of the ground. Tire tracks showed a steady stream of traffic had gone through while I was in court. I called Deputy Martinez again. He came out, took photos, shook his head. "This is getting out of hand," he said. "You've got a court order now. If they violate it, that's contempt of court. But enforcing it is going to be tough if they just keep destroying whatever barriers you put up." "What am I supposed to do?" "You could hire private security. Or," he paused, considering, "you could make it physically impossible to get through. concrete barriers, something they can't just cut or ram through. The next day, I rented a concrete barrier, the kind they use for highway construction. It was massive, probably 3 tons, and required a crane to position across my road. I also had my insurance company come out to document all the damage, and I sent another invoice to the HOA, gate replacement, concrete barrier rental, legal fees, and road repairs now totaling over $60,000. For 2 days, the barrier held. Then I got a call from Harold. "You need to see this," he said. "The HOA has filed an emergency motion claiming your barrier is creating a life-threatening situation. They're saying emergency vehicles can't access the development." That's not my problem. Legally, it might be. If someone dies because an ambulance can't get through, you could be facing serious liability. My stomach sank. Are you kidding me? They created this situation, not me. I know, but we need to respond carefully. I think we should propose a compromise. You'll allow emergency vehicles through, but only with your explicit permission and supervision. You keep the barrier in place, but you control access. We filed our response, and the judge scheduled an emergency hearing for the next morning. This time, Brenda Hutchins brought reinforcements, a dozen angry Meadowbrook Heights residents who packed the small courtroom. Judge Warren didn't look happy. "Mr. Caldwell, I'm concerned about the emergency access issue. What happens if someone has a heart attack?" I stood. "Your Honor, I'm willing to allow emergency vehicles through, but only actual emergencies, verified by 911 dispatch, and only when I'm personally present to open the barrier. I'm not leaving it open for anyone to use." "That's unreasonable," Brenda shouted from her seat. "What if he's not available? What if he's at work or asleep?" Judge Warren's gavel came down hard. "Ms. Hutchins, you will not speak out of turn in my courtroom. Ms. Kendall, control your client." Patricia Kendall looked mortified. "Apologies, Your Honor." The judge turned back to me. "What if you're not available, Mr. Caldwell?" "Then they'll have to use the Forest Service roads," I said, "which is what they should have planned for in the first place. Your Honor, with respect, the HOA is trying to use emergency access as a wedge to get around your injunction. If I leave that barrier open for ambulances, it'll be open for everyone, and they know it." One of the residents, a red-faced man in his 60s, stood up. "My wife has a heart condition. You're basically saying you're okay with her dying." Judge Warren's gavel came down again. "Sit down, sir. One more outburst and I'll clear this courtroom." He thought for a long moment. "Here's my ruling. Mr. Caldwell will install a locked gate that emergency services can access. The combination to that lock will be provided to the county 911 dispatch, the fire department, and emergency medical services only. Mr. Caldwell will check with 911 dispatch daily to verify any emergency access that occurred. If the HOA or its residents abuse this accommodation, the privilege will be revoked immediately. Is that clear?" It wasn't ideal, but it was better than leaving things wide open. I agreed, and the court session ended. As I was leaving, Brenda Hutchins intercepted me in the hallway. "You're destroying people's lives," she hissed. "Families with children, elderly people, disabled residents, all because you're too selfish to share a road you barely use." "I barely use it because it's my driveway," I said, "and I'm not destroying anyone's life. Summit Vista did that when they sold you houses without proper access. Go after them, not me." "Summit Vista has declared bankruptcy," she said. "They filed 2 weeks ago. There's no money to go after." That was news to me, and it explained a lot. The developer had taken the money and run, leaving the HOA holding the bag. I almost felt sorry for them. Almost. "Still not my problem," I said, and walked away. Installing the emergency access gate took 2 days and another $3,000. I used a heavy-duty industrial gate with a digital lock that could log every access. I provided the code to the county as ordered, and I set up alerts on my phone so I'd know immediately if anyone opened it. The first week was quiet. Too quiet. I kept waiting for the other shoe to drop, and it finally did on Christmas Eve. I was at my sister's place in Great Falls for dinner when my phone buzzed with a gate alert. I checked the log. The gate had been opened at 7:15 p.m. I called 911 dispatch. "This is Yannick Caldwell. I have an emergency gate on my property at 4750 Mountain Ridge Road. Can you confirm whether you dispatched any emergency vehicles to that location?" The dispatcher checked. "No, sir. No active calls to that area." I drove back immediately, cutting my sister's Christmas celebration short. When I got to my property, I found two things: fresh tire tracks leading through the gate, and the gate standing wide open with the digital lock smashed. The camera footage showed a pickup truck pulling up at 7:15. Two men got out. One of them swung a sledgehammer at the lock mechanism, and they drove through, leaving the gate open behind them. I called Deputy Martinez's cell phone, even though it was Christmas Eve. He answered on the third ring, and I could hear family noise in the background. "Deputy, they destroyed the emergency gate," he sighed heavily. "Same group as before?" "Can't tell from the footage. Different truck. But it had to be someone from the HOA. "Okay, I'll come by tomorrow morning and take a report. In the meantime, can you secure the gate?" "I'll try." I spent Christmas Eve rigging up a temporary chain and lock system. My sister called to check on me, and I could hear the concern in her voice. "Yannick, is this really worth it? All this stress, all this money? Maybe you should just let them use the road." "It's the principle," I said. "If I let them get away with this, what's next? They already think they can do whatever they want. I can't reward that." "But you're spending your inheritance fighting with neighbors." "They're not my neighbors. Neighbors respect boundaries. These people are trespassers who think money and numbers give them the right to take what isn't theirs." She didn't push further, but I could tell she thought I was being stubborn. Maybe I was, but I'd watched my grandfather work his whole life to buy this land, to build something he could pass down. Letting the HOA steal it, even just the road, felt like betraying that legacy. The day after Christmas, Deputy Martinez came out with his sergeant, a stocky woman named Sergeant Kowalski. They reviewed all the camera footage I'd accumulated over the past months. "We've got enough here to press charges," Sergeant Kowalski said. "Multiple counts of criminal mischief, trespassing, destruction of property. The question is who to charge. Can you identify any of these people?" I reviewed the footage carefully. Most of the faces were obscured or too far from the camera to identify clearly. But one clip from 3 weeks earlier showed something interesting. Brenda Hutchins herself, standing next to the gate while someone else cut the lock. She wasn't doing the cutting, but she was clearly supervising. "That's the HOA president," I said, pointing at the screen. Sergeant Kowalski leaned in. "Well, that's interesting. She might not have cut the lock herself, but she's clearly involved. That could be conspiracy or aiding and abetting at minimum." They took copies of all the footage and told me they'd be following up with the HOA. I didn't expect much to come of it. Police in small-town Montana had better things to do than referee property disputes. But at least it was on record. January brought brutal cold and more snow. My road, already damaged from months of unauthorized use, became nearly impassable. I kept my section barely maintained, but I watched with grim satisfaction as the Meadowbrook Heights residents struggled with the Forest Service road alternative. That route was 15 miles longer, unpaved, and required four-wheel drive in winter conditions. Several HOA residents got stuck and needed towing, which I heard about through the small-town grapevine. The pressure on the HOA must have been intense, because in mid-January, I received a settlement offer. Patricia Kendall sent it via certified mail. The HOA would pay me $100,000 for a permanent easement allowing access across my road. In exchange, I would maintain the road to community standards and allow unlimited access. I didn't even need to consult Harold to know that was unacceptable. $100,000 might sound like a lot, but maintaining a road for 300 households would cost tens of thousands annually. Plus, accepting any money would validate their claim that they had some right to the road. I rejected the offer in writing. The HOA's response was swift and vindictive. Within a week, I started receiving citations from Cascade County. Someone had filed multiple complaints alleging that I was operating an illegal dump on my property, that I had unpermitted structures, that I was violating setback requirements, and that I was creating fire hazards with brush clearing. Every single complaint was either false or a gross exaggeration of normal rural property use. Harold was furious when I showed him the citations. "This is harassment, plain and simple. They're trying to bury you in regulatory problems." Can they do that? They can file complaints, but the county has to investigate each one independently. Most of these will be dismissed once an inspector actually comes out and sees that you're not running a dump or building unpermitted structures. He was right, but it still meant hours of my time dealing with county inspectors, providing documentation, and proving that I wasn't violating any regulations. It was death by 1,000 cuts, designed to exhaust and frustrate me into giving up. The trial date approached slowly. In the meantime, the legal bills kept mounting. Harold was charging me a discounted rate because he'd known my grandfather, but even discounted attorney fees add up fast. By early March, I'd spent over $40,000 defending my property rights, with no end in sight. The night before the trial, I couldn't sleep. I kept running through everything that had happened, wondering if my sister was right. Maybe I should have just taken the easement money and moved on. But every time I thought about giving in, I remembered Brenda Hutchins's entitled sneer, the destroyed gates, the assumption that I should just roll over because they had more money and more people. The trial started on March 15th with jury selection. Harold had insisted we request a jury trial, arguing that local Montana residents would be sympathetic to a property owner defending his land against an out-of-state HOA full of California transplants. He was probably right about that Montana culture has a strong libertarian streak and deep respect for property rights. The jury was seated by noon. 8 people, mostly rural residents, a few from Great Falls. They looked like exactly the kind of people who would understand why I was fighting. Patricia Kendall's opening statement was polished and professional. She painted me as an unreasonable man refusing to accommodate families who had bought homes in good faith. She emphasized the hardship faced by Meadowbrook Heights residents, particularly children and elderly people struggling with the longer Forest Service road route. She promised to prove that a historical easement existed and that I was legally obligated to honor it. Harold's opening was simpler and more direct. "This case is about property rights," he told the jury. "Mr. Caldwell owns this land. He has a deed that says so. The HOA has no deed, no easement document, nothing except an old map showing a road that doesn't exist anymore. They want to take his property because it's convenient for them. But convenience doesn't override ownership. This is America, and in America, we don't let people take your property just because they want it." The jury seemed receptive. A couple of them were nodding. The HOA's case relied heavily on the 1952 survey map and testimony from a surveyor they'd hired who claimed the old logging road and my current road followed similar paths. Harold tore that apart on cross-examination, bringing out our own surveyor who showed that the routes diverged by over half a mile in some places. Patricia Kendall also called several Meadowbrook Heights residents to testify about the hardship of using the Forest Service road. One woman described sliding into a ditch with her children in the car. An elderly man talked about missing a doctor's appointment because the road was impassable after a snowstorm. Harold was gentle with them on cross-examination, but firm. "Did Summit Vista promise you that the access road was legally secured?" he asked each one. "Yes," they all admitted. "Did you verify that with an attorney before purchasing your home?" Most said no. One admitted she'd been told by her realtor that it was all taken care of. "So you relied on the developer's promises without independently verifying the legal status of the road access?" "Yes." "And now you're upset that those promises turned out to be false?" "Yes." "Are you planning to sue Summit Vista for misrepresentation?" "They're bankrupt," several of them said. Harold nodded sympathetically. "I understand your frustration. But Mr. Caldwell didn't make you those promises. Summit Vista did. And now you're asking Mr. Caldwell to give up his private property to fix Summit Vista's fraud. That's not fair, is it?" None of them had good answers to that. On the 3rd day of trial, it was my turn to testify. Harold walked me through the property history, the deed, my grandfather's purchase, and the road construction. I explained how I'd maintained the road for my own use and how the sudden influx of traffic from 300 households had destroyed it. Patricia Kendall's cross-examination was aggressive. "Mr. Caldwell, isn't it true that you use this road only a few times a day?" "That's correct." "So the vast majority of the time it sits empty?" "It's my property. It doesn't matter if I use it constantly or never." "But wouldn't it be a better use of this resource to allow others to benefit from it?" Harold objected. "Relevance, Your Honor. Whether something would be a better use is not a legal standard for taking someone's property. Sustained, Judge Warren said. Patricia tried another angle. Mr. Caldwell, you've spent over $40,000 fighting this case. Wouldn't it have been cheaper to just accept the settlement offer? Probably. But some things aren't about money. This is my property, my grandfather's legacy, and my right to control my own land. I'm not selling that for any price they could offer. Even if it means elderly people can't access medical care easily. They can access medical care. They just have to use a different road. That's not my fault. A road you know is more dangerous and difficult. A road that's appropriate for a rural mountain development. If they wanted convenient highway access, they should have bought homes in town. I could see some of the jury members nodding at that. Montana residents understood that rural living comes with trade-offs. The fourth day brought expert testimony about road maintenance costs, property values, and easement law. It was dry and technical, but important. Our expert testified that maintaining the road for 300 households would cost approximately $30,000 annually, while my personal use required only about $2,000 per year in maintenance. On the fifth day, both sides rested. Closing arguments were scheduled for the following morning. That night, I got a call from Deputy Martinez. Yannick, you might want to come down to your property. We've got a situation. I drove down immediately, and what I found made my blood run cold. Someone had set fire to my gate. The fire department was already there, hosing down the smoldering remains. The gate was completely destroyed, and the fire had spread to some nearby brush before being contained. Arson? I asked Deputy Martinez. Looks like it. Fire chief found evidence of an accelerant. We've got footage from your cameras? I checked. The cameras had been spray painted over around midnight. Whoever did this had planned it carefully to avoid identification. This is escalating, Sergeant Kowalski said. She'd arrived shortly after I did. We need to take this seriously. This is beyond property damage. Someone could have been hurt or killed. Can you tie it to the HOA? Not directly, not yet, but the timing is suspicious, right in the middle of the trial. We'll investigate. I called Harold and told him what happened. He was silent for a long moment. This actually helps our case, he said finally. It shows the kind of harassment you've been dealing with. I'll file a motion to introduce it as evidence tomorrow. The next morning, the courtroom was tense. Judge Warren allowed Harold to introduce photos of the burned gate and the arson investigator's preliminary report. Patricia Kendall objected strenuously, arguing that there was no proof the HOA was involved, but the judge allowed it as evidence of the ongoing dispute. Harold's closing argument hit hard. Ladies and gentlemen, what you've seen over the past week is a group of people who believe that money and numbers give them the right to take whatever they want. They bought homes without doing proper research. They relied on a developer who lied to them. And now, instead of taking responsibility for their own failure to do due diligence, they're trying to force Yannick Caldwell to give up his private property. They've destroyed his gates multiple times. They've harassed him with frivolous complaints. And last night, someone connected to this dispute committed arson on his property. This isn't about hardship or elderly people or children. This is about whether we still believe in property rights in America. Your verdict will answer that question. Patricia Kendall's closing emphasized the human cost and the historical easement claim, but it felt weaker after the arson revelation. The jury deliberated for 6 hours. I spent that time pacing the courthouse hallway, drinking terrible coffee from a vending machine, and trying not to throw up from nerves. Finally, the bailiff called us back in. The jury had reached a verdict. On the question of whether a valid easement exists, allowing Meadowbrook Heights HOA access to the road on Mr. Caldwell's property, how do you find? Judge Warren asked. The jury foreman, a weathered rancher in his 60s, stood. We find that no valid easement exists, Your Honor. I felt my knees go weak with relief. On the question of damages for trespass and property damage, what is your finding? We find in favor of the plaintiff, Yannick Caldwell, in the amount of $87,000. Brenda Hutchins made a strangled noise from her seat. Patricia Kendall's face remained professionally neutral, but I could see the disappointment in her eyes. Judge Warren thanked the jury and dismissed them. Then he turned to the HOA's table. Ms. Kendall, I assume you'll be appealing. We'll need to discuss with our clients, Your Honor. While you're discussing, I suggest you also discuss settlement. This case has gotten out of hand. If it turns out that anyone associated with the HOA was involved in last night's arson, we're going to be looking at criminal charges, not just civil liability. I strongly encourage both parties to resolve this matter quickly and reasonably." Walking out of the courthouse, Harold clapped me on the shoulder. "You won! It's a complete victory." "They'll appeal," I said. "Probably. But appeals are expensive and they've already lost once. My guess is they'll try to settle now." He was right. 2 weeks later, Patricia Kendall called with a new offer. $250,000 for a permanent easement, with the HOA responsible for all future maintenance costs and all repairs to damage they'd caused. Harold and I discussed it extensively. The money was good, enough to cover all my legal fees with plenty left over, but I still had concerns. "What about enforcement?" I asked. "If they're supposed to maintain the road and they don't, what's my recourse?" "We write very specific standards into the easement agreement," Harold said, "with penalty clauses for violations, and you retain the right to revoke the easement if they materially breach the agreement." It took another month of negotiation to hammer out the details, but finally we had an agreement both sides could accept. The HOA would pay me $250,000. They would maintain the road to specified standards with quarterly inspections. They would pay for all past damages. And if they failed to meet their obligations, I could revoke the easement with 90 days' notice. The money hit my account in early May. I paid Harold's bill, paid off the damage repairs, and still had over $150,000 left over. But the story didn't end there. In late June, I got a call from Sergeant Kowalski. "Yannick, we made arrests in the arson case." "Really? Who?" "2 Meadowbrook Heights residents. We got a tip from someone in the community who was horrified when they found out about it. Both men have confessed. They said they were acting on their own, trying to send a message, but we're still investigating whether anyone else was involved." "Brenda Hutchins?" "We're looking into her communications with the suspects. Nothing definitive yet, but there's reason to believe she knew what they were planning and didn't stop it." 2 weeks later, Brenda Hutchins was arrested and charged with conspiracy to commit arson. The news rocked Meadowbrook Heights. Half the community was outraged on her behalf, claiming she was being scapegoated. The other half was mortified that their HOA president had been involved in criminal activity. The trial was quick. The 2 men who'd actually set the fire testified that Brenda had told them, "Someone needs to show that guy he can't push us around," and had specifically mentioned the gate as a problem. She claimed she'd meant they should file more complaints, not commit arson, but the jury didn't buy it. She was convicted of conspiracy and sentenced to 18 months in prison, with 3 years of probation to follow. By the time Brenda was sentenced in October, Meadowbrook Heights had elected a new HOA board. The new president, a retired engineer named Marcus Delgado, reached out to me personally. "I want to apologize for how this whole thing was handled," he said when he came to my property. "Brenda created a toxic culture, and a lot of us just went along with it because we were frustrated about the road situation. But what happened to you was wrong. The arson was wrong. All of it." "I appreciate that," I said. "I also want to make sure we're meeting all our obligations under the easement agreement. I've hired a professional road maintenance company, and they'll be out quarterly to do inspections and repairs. If you ever have concerns, please contact me directly." True to his word, Marcus ran the HOA professionally. The road was maintained better than it had ever been when it was just mine. The traffic lights they installed at the entrance actually made it safer, and having the HOA handling all the maintenance meant I didn't have to worry about grading or gravel or snow plowing anymore. My sister called me after Brenda's sentencing. "Are you happy now?" she asked, but there was no accusation in her voice, just curiosity. "I'm not happy someone went to jail," I said honestly, "but I'm glad I stood up for myself. If I'd just rolled over at the beginning, if I'd let them bully me into giving up, it would have set a terrible precedent. Not just for me, but for anyone who owns property and expects their rights to be respected. I guess I understand that. I'm just glad it's over." Me too. Looking back now, almost a year after that first morning when I woke up to tire tracks in my driveway, I can honestly say I'd make the same choices again. It cost me a lot of money, a lot of stress, and nearly a year of my life dealing with legal proceedings. But I proved something important, that property rights matter. That you can't just take what isn't yours because it's convenient, and that standing up to bullies sometimes means accepting a difficult fight. The easement money is sitting in an investment account, growing slowly. I've thought about what my grandfather would think of all this. He was a stubborn man who believed in doing things the right way, even when it was hard. I think he'd be proud that I didn't back down, that I fought for the land he worked so hard to buy. Meadowbrook Heights is still there, of course. 300 households still use my road every day. But now they pay for the privilege, and they maintain it properly, and there's a legal agreement that respects everyone's rights. The HOA residents and I aren't exactly friends, but we've achieved something like mutual respect. They understand that I could have made things much harder for them, and I understand that most of them were just normal people caught in a bad situation created by a fraudulent developer and an overzealous HOA president. Sometimes I see Marcus Delgado at the hardware store in Great Falls, and we nod to each other politely. Once he bought me a coffee and we talked about the upcoming winter and whether the road would need additional drainage work. It was surprisingly normal, like we were just two people dealing with a shared problem instead of former adversaries in a bitter legal battle. The two men who actually set the fire served 6 months in county jail and were released on probation. I haven't seen them since, and I'm fine with that. Brenda Hutchins is still in prison as I write this, with a release date sometime next spring. I've heard through the grapevine that she's already been banned from serving on any HOA board as part of her probation conditions. There's a certain poetry to that her addiction to control and power over others ultimately cost her both. The whole experience taught me a lot about people and about standing up for yourself. There were moments when I wanted to quit, when the legal bills kept mounting and the harassment seemed endless, and I wondered if it was all worth it over a strip of gravel road. But every time I think that, I remember Brenda Hutchins standing at my gate on that first day, telling me her 300 residents had the right to use my property, and there was nothing I could do about it. She was wrong. And proving her wrong, proving that numbers and money and entitled attitudes don't override basic property rights, was worth every penny and every sleepless night. My road is quieter now than it was during the worst of the conflict, even though more people use it. The professional maintenance crew comes through every 3 months like clockwork. The drainage is better than ever. The winter plowing is handled by a commercial service that does a far better job than I ever could with my truck attachment. In a weird way, the whole ordeal resulted in me having a better road than I started with, and I don't have to maintain it myself anymore. I've been contacted by a few other property owners dealing with similar HOA disputes. Apparently, my case got some attention in Montana legal circles, and now I'm the guy who beat the HOA. I don't know if that's exactly accurate. Nobody really wins in these situations. You just survive them. But I'm happy to share my experience with anyone who needs advice. The most common question I get is, was it worth it? And my answer is always the same. If you're fighting for something that matters to you, if you're defending a principle you believe in, then yes, it's worth it. But you have to be prepared for it to be hard, expensive, and consuming. You have to be willing to see it through to the end, because backing down halfway through just means you've paid all the costs without getting any of the benefits. Would I do it again? Absolutely. Would I recommend it to others? That depends on what they're fighting for and how much they're willing to sacrifice. As for me, I'm back to my quiet life on my 20 acres in Cascade County. I go to work at the lumberyard. I come home. I enjoy my property. 300 HOA residents use my road every day, but now they do it legally, respectfully, and in a way that doesn't cost me anything. It's not the outcome I expected when I woke up to those tire tracks 18 months ago, but it's an outcome I can live with, and that's really all anyone can ask for when you're dealing with an HOA that thinks the rules don't apply to them. You stand your ground, you fight the good fight, and eventually, if you're lucky and persistent, justice prevails. It's not quick, it's not easy, and it's not always pretty. But in the end, property rights mattered more than convenience, and the law sided with the person who actually owned the land. That's the American way, or at least it's supposed to be. And in this case, in this little corner of Montana, it actually worked out that way. I'll take that as a win, even if it came with a higher price tag than I ever expected to pay.